Senator Scullion.
Thank you, Madam Deputy President. Wow, what a debate this has been. Very, very interesting debate I've followed, and lots of passion, lots of people who have welded ideologies, and I have a great deal of respect for all of those views that have been put in this place. And we should remind ourselves really what this place is about. Of course, we call this the States House. Now, a long time ago, we might have had Queensland, West Australia, South Australia, Tasmania, as we go around the country, because those groups of people, those 12 senators that were provided as part of the founding fathers' decisions in our constitution, were to ensure that the states were dealt with equally, that no one state should be discriminated against. Now, I'm actually from a state called the Northern Territory. I don't have statehood per se, but I'm here. And so the whole notion of this debate about ensuring that the states are treated through equally, I have to say I've been a little disappointed that many senators seem to have missed the point. But I'll try to bring them back to that point. So fundamentally, it shouldn't matter where you live, in what jurisdiction, that this place is a place that ensures that you are treated equally. So historically, we're talking now about the restoration, and in fact the legislation is called the Restoring Territory Rights Assisted Suicide Legislation Bill of 2015. So in 1995, the Rights of the Terminally Ill Act on the 25th of May was voted for in the Northern Territory Parliament, a parliament properly constituted, democratically elected, in exactly the same way as every other jurisdiction, same way as West Australia, same way as Queensland, same way as Tasmania, the same way as the Australian Capital Territory, exactly the same way. Their parliaments are constituted in very much the same way. There was a debate, a proper debate that went on. There was committees of inquiry, as you imagine, highly controversial. It hadn't happened in Australia before. A lot of focus on the process. And on the 25th of May, the Northern Territory Assembly voted 15 for and 10 against. It didn't enter into force until the 1st of July in 1996, and in that period of time, 4 people accessed the rights of the terminally ill to assist their passing. So, for all of that to have happened, you look at the legitimacy of how that came about. Well, it came about because of the Northern Territory Self-Government Act that was passed on the 22nd of June in 1978. So they were able to, the Territorians then, make laws for the peace, order, good governance of the Territory where the laws related to any matter not controlled by the Commonwealth. Not inconsistent with other jurisdictions, completely the same as the other states, exactly the same. So we do know that from and the sort of things that they dealt with, of course, were schools, hospitals, utilities, public transport, forests, police, prisons, community services, roads and rails, all of the things that would be dealt with by a state and territory jurisdiction. Nothing too controversial there, and we all accept that's exactly as it should be. And when the Self-Government Act came out, we all felt as equals. We weren't mendicants to the South Australian government or some backyard nobody could afford. We were a jurisdiction unto ourselves. We had the capacity to raise funds. We had the capacity to do the same thing as every state and territory did. Now, we always understood as Territorians that there are some matters that was prescribed as laws related to any matter not controlled by the Commonwealth. So same-sex marriage, for example, has come up, and the Australian Capital Territory tried to raise same-sex marriage, but the Constitution said, look, the High Court struck it down. Eventually the Commonwealth said, well, it is our responsibility, and in this place recently they passed laws on the same-sex marriage that had been prevented thus far constitutionally and by the courts from having a state and territory do that. Well, we respected that. But one thing can I say about the debate today and over the last few days, is that it's been a bit of a Clayton's debate, because we all know that this isn't within the ambit of the Commonwealth Government. This is not a matter in the Constitution that we can deal with. And we know, in fact, that it's been dealt with by those jurisdictions and will be dealt with by other jurisdictions from time to time. Most recently, the legislation has passed in Victoria. Legislation was recently defeated in New South Wales as appropriate, and that's entirely a matter for those jurisdictions. But unlike those jurisdictions, the Northern Territory was functioned in 1997 of the Kevin Andrews Bill, the Euthanasia Laws Act of 1997. So what it effectively did, he said, the self-governments of all territories. Now, there was no mischief in the ACT. No one was trying to pass laws about euthanasia in the ACT, but we'll throw them in anyway to make some sort of a consistency, as to prevent them from passing laws on euthanasia. So they're quite entitled as jurisdictions to pass laws on euthanasia, but because the fact that we're slightly different as a territory, we could pass a private member's bill that would not have stood a chance in hell of getting up in New South Wales or Victoria or overturning any of those, and no attempt has been made to control those jurisdictions because of their rights under the Constitution. So that passed through this place on the 27th of March in 1997 with a vote of 38 versus 33. So 38 people said, no, we want to deal with the matter of euthanasia in the Northern Territory, and I can understand at that stage. It was a reality, and it was an opportunity for people whose fundamental beliefs about euthanasia were probably more impacted than those of the rights of the Northern Territory. But euthanasia is not a matter for us, and that's why I've indicated plenty of passion, plenty of smarts around this place. But it's a bit of a Clayton's debate, and I can tell you right now there's a difference in the sense of this place. If we were debating euthanasia as a national piece of legislation, that place would be full. That place would be full of media. There'd be people running around. The back rooms would be full of people ringing, cajoling. But it hasn't been like that, because we know it's not going to change anything about euthanasia nationally. We're not doing anything federally, and it's not within our ambit constitutionally. So, really, I've heard in here there's a broad agreement that the Restoring Territory Rights legislation is really not going to be impacted. So the Right to the Terminally Ill Act are not going to be impacted if we pass this legislation. And if I can just provide some focus on some legal opinion that was submitted to the Senate on Legal and Constitutional Affairs into the inquiry into the Right to the Terminally Ill Repeal Bill in 2008. And the observation is as follows. There is significant judicial and academic opinion which suggests that laws made by territory legislatures are not merely suspended or dormant for the duration of any inconsistent Commonwealth law and then back into force upon its removal. The authors concluded that there are strong grounds for suggesting that the bill may be insufficient to revive the Right to the Terminally Ill Act, and the rights of individual and interest at stake are too important to allow uncertainty on this score. Another legal submission raised concerns that an attempt to revive the bill would provide an argument would be vested with a federal character and didn't possess prior to the commencement of the euthanasia laws of 1997, or would not possess the mere repeal of an act, and that meant there was a real danger of the RTIA becoming entrenched and leaving the Northern Territory Assembly powerless to amend it, in a sense, because it had this Commonwealth flavour. Professor George Williams of the Gilbert and Tobit Centre told the committee instead of the NT law being revived, the Legislative Assembly would be able to pass a new law should they so wish, and they should be allowed to do so. I think it appropriate, given principles of democracy involved, given the time that has lapsed and also the constitutional issues, rather than attempt to revive something that may not be possible to do. And it would certainly be inappropriate to leave practitioners and others in a situation where they may be unclear as to the legality of their actions. All subsequent federal bills to restore territory powers, including the current bill, have made it clear they do not attempt to revive the rights of the Terminally Ill Act. So what remains, Madam Deputy President, what remains for us then if this is not a matter either within the ambit of the Commonwealth and the Senate to decide on? It's not about euthanasia, and I haven't talked about my issues about euthanasia because I shouldn't. It's not my right to do so. It is the rights of states and territories to deal with that matter, and that is clear in the Constitution. So what remains? This debate is not clearly about euthanasia. The only issue remains is about the territory's rights to make laws that are not controlled by the Commonwealth in the Constitution. And it's been quite a disturbing process, Madam Deputy President. So, spatially, by dint of history, if you happen to live here in the Australian Capital Territory, or if you happen to live in the glorious Northern Territory, you are now a different class of citizen. You don't have the same rights to decide what you want as every other jurisdiction. And in this place, in the Senate, to choose to ignore that fundamental, I find it very difficult to swallow. And I've heard so much about equality in this place. We're all equal in this place, and we've really got to look after equality. But this was an opportunity to right the wrong of the 27th of March in 1997, where every person who lived in the Australian Capital Territory and the Northern Territory became a different class of Australian. Are we equal? Well, sort of. We're equal unless the Commonwealth decide that you are not. That you are not. So this is not a debate about euthanasia. Clearly, it should not be a debate about euthanasia, although I acknowledge and respect those people with strongly held views on those matters. This is only about state rights. And so can I say, Madam Deputy President, I'm not sure why the people who enjoy living in a state don't trust me, don't trust Territorians to democratically elect people who will make decisions in the same way as everybody else does in Victoria and New South Wales, Tasmania, West Australia or Queensland. In exactly the same way, but we can't be trusted. We can't be trusted. And people have said, oh look, the Northern Territory didn't become a state when it wanted to become a state. Let me tell you, we had a constitutional referendum about statehood, and it failed. It failed because people didn't understand what we were about to get. But can you imagine, even if it had passed, people coming into this place and saying, thanks very much, and where's our extra 10 senators? What a bloody joke that would be. Because this place, I can tell you, after what I've heard over the last few days, is not a place of equity. It's not a place that respects everybody who lives in this country. Those people who are voting this down, and I genuinely respect their views on the fundamentals of euthanasia, but that is a Clayton's debate. That is a Trojan horse that just doesn't cut it. There's an opportunity today to put right something that went wrong on the 27th of March in 1997. Now, Territorians for 19 years were okay. Territorians for 19 years were okay to get on with their own business because it was consistent with some of the views of people in the Commonwealth Government. But the day it wasn't, they sent a clear signal. And to the ACT, who hadn't had the temerity to be able to introduce legislation of their own, even those would be caught up because it would somehow be consistent. What a lot of rubbish. Now, nobody in this debate needs to be absolutely anything but clear about what this is about. This is about entrenching two types of citizen in this country, one who comes from a territory and the other who comes from the Commonwealth. And I can tell you, introducing 20 new senators in this place is not going to happen in my bloody lifetime. So the notion of, oh, why don't you just become states and then you'll be the same as us, is complete garbage. So those glorious 19 years that we were treated as equals around this country, there's an opportunity today to ensure that we are returned just simply as equals. Territorians aren't asking for any more than that. We are simply asking in this place, in this House, to be treated as equals.